Hey, I'm Patrick Stegall. I'm a criminal defense lawyer in Memphis, Tennessee, and today I'm going to talk about preliminary hearings. We're going to talk about what are these types of hearings, how do they work, and should you have one in your case. Preliminary hearings are evidentiary hearings that are conducted at the beginning of a criminal prosecution. Any type of criminal case, whether it's a misdemeanor or a felony, in Tennessee, you have the right to have a preliminary hearing when your case is in General Sessions Court. General Sessions is sort of the lower court. We sometimes call it the inferior court. And then some cases move up to the criminal court or the circuit court, depending on the county you're in. So you can have your preliminary hearing when your case is at the lower level, the General Sessions level. You don't get a preliminary hearing once it moves up. And so you have to decide if you want to have a preliminary hearing in General Sessions or if you want to go ahead and settle it. Generally, I recommend to clients, if you're facing a case that can be settled in General Sessions, typically a misdemeanor, or if it's a lower level felony, a non-violent type of felony case, where you may be able to go ahead and get a good settlement, I would do that rather than have a preliminary hearing. I really only recommend having preliminary hearings if you're pretty sure that you want to have a trial on the case. If you want to have a trial, go ahead and have your preliminary hearing because you know the case is going to have to go up to the criminal or the circuit court, because that's where you have your trials. You can have your preliminary hearing in the lower court, you can have your trials in the upper courts. So go ahead, if you want to have, if you're thinking about trial, go ahead and have your preliminary hearing because you know it's going to go up later on for trial. And that leads to the question of what exactly is the preliminary hearing good for? It's not a trial. It's not winning or losing. It's not guilt or innocence. You're doing it simply to gather evidence. It's sort of like a deposition where the state has to bring its proof to court, but they don't have to bring all their proof. At a preliminary hearing, the level of proof required by the state is very low. It's probable cause. That is the lowest legal standard we have in our system. It's basically enough evidence to arrest somebody, but it is well short of evidence needed to convict. So all they have to show at a preliminary hearing is probable cause. And that means they don't have to put on every witness and show every piece of proof to you. They just have to have enough for probable cause. But still, those are a good way to gather evidence, see which witnesses are going to come to court, what those witnesses say. Your lawyer gets the chance to cross-examine them under oath. So at a preliminary hearing, again, if you're thinking trial down the road, that preliminary hearing is a good way to kind of get a sneak preview of what they're going to have at trial. That's why I generally only recommend having a preliminary hearing if you're planning on having a trial. If you think it's a pretty good chance that I'm going to have a trial on my case, then yeah, have your preliminary hearing and see what the witnesses are going to do. But if you're facing a misdemeanor or a non-violent type of felony, and if you're a first-time offender and you want to get a good deal, there's really no point in having a preliminary hearing. It would be better to focus your efforts on resolving the case and keeping it off your record. So, each case is different. It really depends on what you're charged with, what do the facts look like, and what do you want to do. But if you're going to go the preliminary hearing route, then get ready for it and see what their witnesses say, and then you have that testimony under oath on the record, where if it later on goes to trial, those same witnesses are going to have to come back to court, and if they say something different at trial, again, it's like a deposition. If they say something different later on, you can use that to help your case. Again, my name is Patrick Stegall. Thank you for watching.